Hey, I'm super excited tonight that I have attorney Jacinda Walker of the J Walker Law Group. And the last live that I had, we had so many questions about deeds. So one of the questions we got was somebody wanted to quit claim the deed to their family member so they could take over the payments. And I was like, we need to get an attorney to answer some of these questions before y'all give your houses away. So I'm so happy to have Jacinda here. The last video we did together, she helped me do a video about getting out of your lease to buy a house.
Yes.
That's still on the channel. So if you haven't seen that yet, please take a look at that. But I'm going to allow her to introduce herself. I'm going to ask some just general questions, and then I'm going to open the floor up so you guys can get your questions answered. Hey, Jacinda, thank you for joining me.
Oh, thank you so much for having me. My name is Jacinda Walker. I've been practicing for about 13 years, and my area of practice, my primary area of practice is real estate. I literally launched my own firm in March of this year, so I'm very excited. We're coming up on 1 year, but I was a partner at my previous firm. So I've done big law, I've done small law, I've done everything in between. I've been in-house and worked in real estate as well. But I always tell people real estate literally is my life. It's my investment plan. I'm a real estate investor as well. I'm an international real estate investor. So I really do believe in the process. So I try to pride myself on learning as much about real estate as I possibly can, because I do believe that it could be, basically your retirement plan. It doesn't have to be, real estate has enough space where you're allowed to have variation and you can vary within the same field. And I think real estate is one of those unique fields where you can have that variation.
Well, so I'm super excited to have you. I'm going to start with my general questions. If you want your question answered first, you need to make sure you're putting those questions in the chat. Maybe after we'll prioritize. We have the moderator in the chat. We're going to prioritize deed questions. However, if you have any other general kind of questions a lawyer will be helpful for, then we'll add those in there as well. So thank you for joining me. Those of you that are already here, I see Angelica from New York. Hey, Angelica. And Mimi right here from Lawrenceville, so not too far in Metro Atlanta, Gwinnett County, for those of you that are thinking about moving to Georgia. All right, so my first question, Jacinda, is what exactly is a deed? What's a deed?
So a deed basically transfers some type of ownership. It literally is a document. They're typically 1 to 2 pages, very basic. It kind of explains the legal description of the property. It describes the property, and you're transferring interest from one person to another, or you're adding interest, so you're adding someone onto a property. But a deed is just a legal construct we use, a piece of paper that we file at the courthouse that says, hey, I'm giving this property to so-and-so, or I'm adding so-and-so to this property. And that's all that a deed is. It's actually a pretty simple document. It just gets more complicated as we move through real estate transactions.
Okay, good. Now, is there a difference between a deed and a title?
Technically, yes. When attorneys say that we are reviewing title, we are looking at the entire real estate record. So generally, when we pull title, like when you pull title for a closing, we pull title generally for 50 years, sometimes up to 100 years, depending on the property. So when we say title, it means the complete real estate record. So the deeds, the mortgages, any liens on record, any affidavits on record. So we're looking at probate records. We're looking at the entire recorded history of a property versus a deed. It's just one document.
So, but you may be looking, when you're looking at the whole title, you're probably looking at multiple deeds.
Absolutely. Multiple deeds. Title. We're looking at multiple transfers, multiple mortgages. Because think how many people own a property in 100 years or 50 years. Right. It could go through several owners. It's rare that we see a property that's owned by one person for 50 years. So typically we see, on average, when we're looking at for a closing, we see about 3 to 4 transfers within a 50-year time frame.
Okay. And then my other question, before I ask this question, I'm going to go back and forth when I put things up on the screen. But Rochelle asked, and this is a good question, are these questions based around Georgia law? So, of course, Jacinda is licensed, a barred in Georgia. However, she does have, and I'll let you say this too, some people, she probably give you a general answer. Does that make sense? Because a lot of the deed things are, the same from state to state. However, if you need legal representation, she's going to have you reach out to her and refer you to somebody maybe in your state. You want to speak more about that, Jacinda?
Yeah, so the interesting thing is most attorneys, we learn generally. We don't learn state-specific law while we're in law school, believe it or not. We don't learn statutes and stuff when we're in law school. We learn general concepts. So when it comes to general concepts, yes, I can speak on general concepts, but I'm only licensed to practice in Georgia. So if you contact me for specific advice, I'm only going to answer questions remaining regarding Georgia. If you need help with another state, you can still contact me and I'll try to find you assistance, somebody else in another state. Attorneys, we try to network all the time in order, to build up our network, in order to become more valuable to our clients, and in order to send good referrals to other people. So you can absolutely contact me even if you're not in Georgia, and I can refer you to someone in your state.
Okay. And I put our contact information. We'll probably try to put a little bit neatly, and it'll be in the description of this video. For anybody watching the replay, it'll be in the description. So I want to ask some of the questions from the last chat, and then I'll take your questions. And like you said, she does real estate closing. She's been to law school. She knows everything pretty much about real estate. And so she's going to be a great help. Even she also said real estate investing as well. So one question that was asked during the last live was, if a spouse passes away and they're on the deed with you, do you have to get them removed from the deed, or can you just leave them on there?
So yes, the short answer is they're going to be removed, right? So for most people, when a spouse passes away, we call that some sort of joint tenancy, right? And so because there's a joint tenancy, that means they have their own interests. So if it's me and my spouse, my spouse passes and I own it in just a straight, what we call, common joint tenancy, they would own 50% of the property. Okay, so 50% of the property goes to their estate. I'll need to probate that to get permission to take away their 50%, to send it to whoever it's supposed to go to. More often than not, that's going to be me, the wife, but sometimes the spouse will have additional wishes. They'll go to their kids or to another heir. Okay, they can do whatever they want with their 50%. This is where wills are important, right? So if they want something specific, it has to be in a will. If it's not specific, we're going to go by state law. Okay, so state law will determine it. And every state has their own, what we call intestate. It's spelled INTESTATE, intestate succession plan. So they'll have a plan of how heirs are determined. And that's determined by state law. So every state has their own intestate succession plan, and you can look that up and figure out how your state works. But that's generally how it goes. Now, there are some states that have special tenancies. So Georgia and Tennessee are one of them. We have a joint tenancy with the right of survivorship. There are several states across the United States that have survivorship elements. And generally speaking, what a survivorship element does is, if you and your spouse are on the deed, or you and your children, right, or you and your child, the last surviving person owns it in fee simple. So fee simple, when we say fee simple is like how you normally think we own property, right? It's the most popular tenancy that we have. I own the property. I can do what I want with it. It is mine, right? I'm not leasing it. I'm not sharing it. I own it in fee simple outright. That's what we mean by fee simple. So if my spouse was to pass and I had a joint tenancy deed in Georgia, I would have to file an affidavit, and I could skip probate. Okay, I get to skip probate. I don't have to go through the probate process, and I would be the sole owner of the property. So like, I have 2 children. My plan is to leave them both with a joint tenancy situation. So they won't have the tax liability of the property.
All right. So that almost, Jacinda, that leads us to the next question was, are adding people to your deed. So you were saying you're maybe perhaps doing that to your children. Can you add anybody to your deed without their knowledge? In most cases. So if I want to add my children to my deed, do they have to agree to be added, or can I just add them? If I want to add my sister to my deed, she have to come to the law firm with me, or can I just add them?
You should. Now, technically you can. It's not good practice, because basically you are putting their name, you're adding them a commitment. You're making them a commitment to a certain property. And to the upkeep of a property, because what happens is, when a property gets added to my name, like, it becomes attached to me. So if that property goes through foreclosure, it's attached to me. If that property, the taxes are behind, it's attached to my name.
Let's go back a little bit, because I used to be a teacher, and I had this happened to one of my students. Their brother added them to their deed. without them knowing. So that's why I know you can add it, because you don't have to have their permission. So he added that student to the deed without them knowing. He goes to jail, and they're behind on the HOA payments, very similar to what you're saying. I think it was about to go into foreclosure, and all these creditors were calling her, and she had no idea she even owned a property.
Correct.
So,
Georgia has this unique system that I don't like. I'm not going to lie. Where you can pretty much file anything on the real estate record. It doesn't mean that it's valid, but you can file it. And so if somebody files something with your name on it without your permission, there is a legal process where you can have your name disassociated with something, especially if you didn't give permission for it. But you would have to go through that legal process. So in Georgia, technically, yes, they can do that, but you want to be careful. Like, I would never add. And then Georgia has a limitation too, right? Your kids you have to be 14 years old in order to be added to a property here in Georgia legally, even though people do it incorrectly all the time, but it's not valid until they're 14, right?
Okay, good to know. And do you think that's in a lot of states? It has to be a certain age?
A lot of states have an age limit in which you can own property.
Good question.
So, every state's going to have their own age limit. But yeah, I want my kids to know, because this is their inheritance, right? So it's a different scenario. But you always, you're supposed to get permission. Some states actually require an affidavit from the person that you're adding on, and I wish Georgia would take that up.
Okay, very
good.
Some
states are gonna nullify that, and they're gonna have a system that requires the other person to know. Georgia just hasn't caught up to that yet.
Okay, good to know. Okay, so this is my last one that I'm going to ask. Then I'm going to take the audience questions. Okay. We have about 86 people on the chat with us. So go ahead and hit the like button. If you're not subscribed, hit the subscribe button, and we'll put Jacinda's information in the chat for those of you just signing in. All right, so this was the question that I spent the most time on as a non-legal person a couple of weeks ago. It was a lady wanted to know whether she should quitclaim deed her house to a relative, so because she couldn't afford the mortgage anymore. And so the relative said, okay, you can't afford the mortgage, quitclaim deed the house to me, and I'll take over I'll start paying your mortgage. I'll make the mortgage payments. And in my non-legal advice, I said, don't do that, because you're giving them ownership of your house, but you still have the 100% responsibility of the mortgage.
Correct.
So explain why that's not a good idea from a legal perspective. Like, so somebody, you're
right. So you can't take it back. If she changes her mind later on, she can't reverse the process without that person willingly signing their name back over. So once you give whatever you give, it's permanent, right? That's one reason why you really need to think through these things before you do that. Number two is, depending on how her mortgage is set up, it could trigger the pay on due. It's like a
pay on demand,
it can trigger that clause. And so you got to be careful depending on how the mortgage is set up. You don't want to have to pay your full mortgage immediately because something has happened with the ownership of the property. And sometimes if you're no longer the owner, you can trigger that clause, and it causes the mortgage to be due in full immediately. Okay. So that's another reason. The third reason is it's actually for the other person. You don't know what else is going on with this property. You don't know if taxes are behind. You don't know how close it is to foreclosure. You know how damaging foreclosure can be with your name attached to it. It shows up on your credit report, right? So because you are an owner, even if you're not on the mortgage, because you're an owner, you're still going to be included in the foreclosure. Okay. So it's just really important that you are aware of what you're taking on. And I always tell people, quitclaim deeds, all they can do is give you the ownership that the previous person has, right? So if the previous person has 100% ownership, you're passing on 100%. But if the previous person only has 50% ownership, you're only getting 50% ownership. So he doesn't even know if she's 100%. Is that person 100% owner of the property?
Wow.
There's so many. If they own 0% of the property, you're zero interest. And that's why in Georgia, we're an attorney state. They require closings to go through an attorney, because the one thing that we do is we look on the real estate record and we're like, okay, well, what's going on with this property and who is the true seller? You got to establish that first. Who owns it? Who has to sign off in order for this sale to happen and for this person that thinks they're buying this property to be whole and to own it 100%? What has to happen for that? So yeah, it's just on both sides. There's caveats. Typically, quitclaim deeds are used amongst family when you know what's going on beyond a shadow of a doubt. You know what's happening with the property. So like if my grandmother owns a big plat in McDonough, and if she had siblings and the siblings no longer wanted to be a part of it, the siblings could quitclaim their interest back to her, but they know everything that's happening with the property. There's no surprises. I don't like quitclaim deeds, so I'm going to be honest with you.
Right.
I don't like them. I genuinely like you to go through an attorney and understand the process of what's happening. Quitclaim deeds are most commonly used, like if I'm transferring my interest from myself to a company, to my company, or to a trust. That's typically when we use quitclaim deeds the most, or again, amongst family. But you got to be careful. You got to know what's going on with the property.
All right, good. All right, so let's take our first question. I think the moderator closed me out. How do you prevent deed scams and theft? So somebody stealing your deed. I know there's a lot of like deed theft where people were, especially for paid off houses, they were getting the deed or putting the deed in their name and then evicting the owners, that sort of thing. Is there a way, and just speaking generalities, I think, not Georgia specific, how people can protect their deed?
Check the real estate record. Check the real estate record multiple times a year. I would do it quarterly. There are certain states, including Georgia, that have services that you can sign up for. So if anything it happens on the record with a property that you're registered for, you'll get a notification.
Okay.
Also check your property tax bill, because anytime there's a change in ownership, it'll show up on your property taxes. You can log in and see it. You'll be able to see if there's a change of ownership. So typically, in order for that to happen, there has to be a significant amount of time that has passed and it has gone unchecked. So what you want to do is just continuously check the process. And if you find out that someone has erroneously, right, because it could be an error, hopefully, right, or they're trying to do some sort of fraud or theft when it comes to your property, immediately contact a real estate attorney and contact the police department. You want to get that police report on file, and then you want to go to a real estate attorney. Typically, what you would have to do at that point is file what we call a quiet title action. Okay. A quiet title action is going to say, hey, this isn't valid. This is fraud. And this person I did not sign over my property. This is incorrect. And it'll clear up the real estate record, clear up what we call a cloud on title. So any errors or anything that's not clear on title, it'll clear. The quiet title process clears that up.
All right. So if there's any kind of monitoring system in your state, find out what that is and put your deed to monitor it. Yeah, and then if you have older family members,
your address.
Sorry, go ahead.
Your address that you register per address most of the time.
Okay. So register per address. And if you have older family members, you may have to do it for them.
Yes.
If they don't know, because a lot of these things are online. So if you have older family members, do it for them. And she's saying, go ahead and just make it a habit of checking your deeds and your ownership quarterly.
And your older family members too. Check their ownership. Check the deeds. See what's happening. Check in, roll in for them. Because I mean, honestly, like if you had 10 properties, it would only take you half an hour every quarter to go in onto the online system and just check to see what the last thing is. Because the way the online systems work is whatever is last in time is what you'll see first on the real estate record. So it'll take you 30 minutes.
Okay. Excellent. All right. Our next question coming up. I think I saw it. Oh, this is from Mimi. Thank you, Mimi. I'm single, no children. If I have no one listed on my deed, what happens to my property?
So it goes, if you have a will. Do you have a will, Mimi? So if you have a will, your will dictates first. So you get to say, if you have a will, your will dictates where your property goes. If you don't have a will, we're back to interstate succession. So typically that is your parents and then your siblings, and then it kind of branches out from there. If you don't have any, what they consider legal heirs, children or a husband, it goes directly up to your parents and then to your siblings. And then it kind of filters out from there, depending on the state.
All right. And just to make a note for Mimi and everybody else, I've done 3 videos. Every Black History Month, I do lives with an attorney about probate or trust and wills. So please watch those videos, because I've had a situation close to my own family where my cousins, they had an issue, after their mom passed away. So you want to, and she had a will. So we just want to make sure that you're protected as to where that you want to know for sure if somebody passes away, especially your parents. If you know your parents don't have a will, this is a conversation you need to start having with them now.
Absolutely.
Because you're going to be fighting, not fighting, not going to put that out there, but you could be fighting over property if they pass away. And this is particularly important as well if you are in a second marriage or a second relationship. Maybe, you bought a house together and y'all both have children that are not your children. You maybe share some children, you don't share all the children. Make it very clear if somebody passes away where that property goes. And you have to, like you said, if you want to make that decision, it has to be in a will or a trust. If not, the court's going to make it for you. And like Jacinda was saying, it's parents first, then your sibling, that kind of thing.
Yeah.
So especially if you have no children. I think if you have children, it's your children first, right?
It is your children, but she doesn't have any. But yeah, if you have children, it would be your children first. Absolutely.
All right.
But if you don't have any, what they consider heirs, right, then it goes back up to your family and down. But if you have children or grandchildren, those will be your first line of heirs. Your children and grandchildren will be your first line of heirs. But Mimi, you could also, if you know that you want where you want your property to go, like say if you decide to remain childless, right, and you don't get married, because I understand the headache, okay? So let's say you don't get married and you remain childless, right? Maybe you want your house to go to your sister. You could go ahead and take advantage of a special deed, depending on your state, what state you're in. You could take advantage of that joint tenancy deed and go ahead and put your sister on the deed right now. Like you could just go ahead and make her a joint tenant right now if you're the older sibling. So I mean, it's important to plan, right? So no matter what you're doing, it's important to plan. You could have a will and you could take advantage of a special deed, depending on, how everything is set up, how you want to leave things and, at what age. Because, just keep in mind too, a joint tenancy. One of the things I always like to keep in mind is like, I probably won't do it for my main property because if I want to refinance my primary residence, I won't be able to do it, without the signing off of somebody else if I have a joint tenancy deed. So that's another important part. If you are an investor and you do the BRRRR method, which is like buy, you fix it up, you renovate, and then you refinance and pull the equity out, you're going to need them to sign off on anything you do with the property. So just keep that in mind as well.
Okay, good to know. All right, our next question. Thank you, Mimi. Hello, Pamela. Hello from Maryland. After you pay off your home, are you sent the deed or do you have to request it?
Yes. So it should be sent to you once you pay it off. Now that's going to vary by state, honestly. But generally speaking, what happens is the mortgage is canceled. You receive the cancellation of the mortgage, and then you should receive the actual deed. Like it should be on the real estate record that there's no mortgage, and you'll have an actual copy of the deed. You should be able to get a copy of your actual deed at any point. So certain states, I want a little bit of clarification. Some states, you don't actually own the property until you pay off the mortgage, right? That's how some states are set up. In Georgia, we own our property whether the mortgage is paid off or not. So certain states, like you own it regardless of whether the mortgage is paid. If you're in one of those states where you don't own it truly until the mortgage is paid off, yes, it will be sent to you. If you're in a state where you own it, regardless of who the mortgagee is, if the mortgage is paid off or not, your deed is always at the county courthouse and you can get it anytime.
Okay. Good distinction to be made. Because I was like, I already have my deed.
Yeah. Certain states, yeah. Some of the northern, the Northeast, y'all a little different. I don't know why they do that to y'all, but it's a little bit different in the northeastern states.
All right. Good to know. All right, Deborah. Hey, Deborah. What if you have property before marriage that you already put in a trust to your children? Will the new husband have rights to that home?
No, that's the benefit of the trust or an LLC or a corporation. It is out of it's not a marital asset at that point. And it's something that's already been designated somewhere else. So it's not an asset that would be considered a part of your estate at that time.
All right. So that's one way to protect your children from like a prior marriage. Just make sure he know that if something happened to you, he got to find some place to live. All right. Thank you, Deborah, for that question. All right. Joe Smith, I was left a house in a will. The property is still in the deceased person's name. How do I transfer the property into a business name? I'm in Colorado. I think she's going to give you a general answer, but good question to have.
It is.
All right.
Generally, you would have to go, if it's not a special deed, like a joint tenancy deed. So if it's a special deed of some sort, you would file an affidavit, and that's all you would need to do on the real estate record. And you would, so there's not much that you have to do. If it's not in a special deed or you're not in a state that allows special deeds, you generally have to go through probate because it was left in the will, right? So you have to go through the probate process. Someone has to be named the executor or the administrator, depending on the state what they name it. In Georgia, we call it the executor when there's a will in place. Okay, and it goes through the probate process. The judge says, yes, I agree with you. This is what the person wanted. And the executor, and it could be you or it could be somebody else, signs over the will to you. And there would be a special executor's deed that will be filed, or administrator's deed, depending on the state, that will be filed specifically from the estate to you. Okay. And then once it goes to you, you can use a quitclaim deed to go from you to your business.
All right, let me ask you a question. I guess to expand on this, that might help other people. So say, I don't know if this still has a mortgage on it or not, the house that he was left, but say the house does have a mortgage on it, but it has to go through this process before it gets to Joe. Should he be paying the mortgage in the meantime? So it doesn't
Absolutely.
go to, okay.
Absolutely.
I feel like a lot of times, especially when people are not aware of what's going on, what will happen is it's happened for so many years. Nobody's paying the mortgage. They're trying to work this stuff out. And then the house goes into foreclosure. And maybe the asset that you thought you were getting is no longer really an asset. Or, you know, if it has a mortgage.
Right. Yeah. Or, because of the fees. Yes. Do you want to pay the mortgage in the meantime? When you're going through the probate process and going through the probate courts, you'll be given, for lack of a better word, credit for what you paid into it. That'll be factored in. So if it's multiple people, who are being given an asset, whoever is paying the property tax or the mortgage will be given credit for that in their share of what they should be receiving. So I'm gonna be honest with you, in those circumstances where it's being given to you, the best thing is to try to refinance out of it. If you want to keep the asset, is to refinance it out of the previous mortgage. Or, of course, if you have cash to pay it off by all means. But you want to wait until the asset's in your name and in your control before you pay it off. But you do want to pay the monthly mortgage payments in the process of in the interim of going through the probate process. But yeah, once you get it, the best thing is to refinance out, because that mortgage is now going to become due. They know the person has died. You've gone through the probate process. It is very clear to the mortgage company. So you're going to want to plan to refinance quickly, or you could sell the asset as well.
Okay. And then lastly, because I know you're the tax lien, we're going to have Jacinda back on for tax liens at some point. She needs to pay the taxes too, right?
Yes. Pay the taxes. Please pay the taxes. Now, the taxes are only due typically once a year. Depending on what state you're in, you might be able to get an extension, a loan. There's different things you can do with taxes. But y'all, pay the taxes is just as important as paying that mortgage, because you do not want to have to deal with a tax lien, or if you're in a tax deed state, you don't want to have to deal with the property possibly getting auctioned off before you get to that point.
Okay. Thank you, Joe. I'm sorry for your loss. Hope that was helpful. Let me ask you one more question before I read Ty's question. For your tax lien class, or the class that you give, I'm gonna have you back on for that. Is it nationwide, or is it just?
It is. Now, the tax lien class is nationwide. I do that through my consulting company, because the process is pretty similar. Now, every state has a different process. I'm not going to lie to you guys, but the process of what you have to do leading up to it, your homework, your due diligence, it's pretty much the same. It doesn't vary by state. So.
Good to know. So y'all see all those YouTube videos when people are buying these houses for $1,000 or $100 or $500. Jacinda's going to teach us all how to do that. All right. So I'll have her back on. If you want me to have her back on for that, put it in the chat. All right. Ty's question. I think we might have answered this. Let's see what Ty's asking. What if only one spouse is on the deed and if the other should pass away? Similarly, what if the mortgage is only in one spouse's name? Does this affect the deed? So I think we already answered the first part of that question, Tay. So I just want to answer that second part. What happens, or explain to people, when can somebody be on your deed and not on your mortgage?
Absolutely. See it all the time, especially with spouses. Okay. You'll have a husband or a wife. Maybe they have like a business and they don't want the asset. They don't want their name to be tied to their personal home. Or they're not working. Like if you have a stay-at-home spouse, they don't have any income, but they will be on the deed. They just won't be on the mortgage. And so what happens is when somebody passes away, you're going through the probate process. You hopefully you have life insurance that is going to pay your house off. So when we talk about spouses, I hope that is the case. I hope that we have planned for enough life insurance to take care of the mortgage, so you're taking care of your significant other, right? And then what we're going to do if once you get through the probate process and the house is typically, more often than not will be given to the spouse, then you would deed it to yourself as the executor of the estate. So we're back into the probate world now. So we're probating his will, or if he doesn't have a will, we're going by interstate succession. Okay. So it's just really important for you guys to have these conversations with your spouses. I know we're talking about real estate, but I can't stress enough how important the will function, the trust and estates function, just planning for your future. Because your spouse and your kids are important, but so is your spouse, and you want to make sure they're taken care of.
Okay. Let's not moderator. You can put up the next question while I ask her this. Let's talk about boyfriends and girlfriends, because people are quick to put their boyfriends and girlfriends on a deed, and they don't have the same protections you might get with marriage and the divorce process. And sometimes like that boyfriend or girlfriend is helping with the mortgage. They're not on the mortgage, but they're helping with it. They add them to the deed. They're never on the mortgage, and then they break up or something happens. And now you're trying to sell or something, and they own your house, or they own a portion of your property. So say it again, please.
Not do it. No, under any circumstance should a boyfriend or a girlfriend be on your property ever. No, just don't.
Okay.
Until you have signed the certificate that says I do. I don't care if you got a ring on your finger. I don't care if the wedding is supposed to be in 6 months.
Right.
Please don't put anybody on your property. It's just too easy to add them after y'all are married. It's too easy. Just wait.
Don't do it ahead of time. Don't do it ahead of time. I've heard, I'm just on the real estate side. I've heard horror stories of women, for the most part, that contact me or reach out to me, and they broke up, they moved out. Now they have to buy them out or pay them off in order to get their name off the deed. And they're going to, sometimes they're getting $50,000. Mind you, they haven't paid anything, and they're, getting money just so they can be released, or she can be released to sell the property or to refinance the property. So I double, what Jacinda says, do not do it.
Do not do that. And if you're doing an investment with somebody, I recommend that y'all do it under a company, and you have the operating agreement kind of dictate what happens if you guys are no longer partners, right? So even if you're investing with somebody, I wouldn't put my personal name on it, and I wouldn't put multiple personal names on it. I would just form either a joint venture, or you guys form a company together. Even as boyfriend and girlfriend, don't do it.
Don't do it. All right, good to know. All right, Patrick. Patrick says, my mother claims she is going to put do not sell in the will or trust. I live in a different state and don't want to deal with the house upon her death. I would like to sell it. Can she do that? So basically, she's going to put in her will or her trust, you can never sell my house.
So you can't do it in a will. You can't do that in a will. Okay. But there are certain trusts that you can do that. She can set up like a family trust. But the problem is if she doesn't have enough money. So people who typically set up family trusts are typically on the wealthier side. And so the trust itself is able to maintain the property. If it comes to the point where you have to maintain the property, you could have to say so, depending on the state. So it is possible if she can get a really good trust set up. They're expensive though. They're not cheap. I mean, we're talking about somewhere between $5,000 to $10,000 to set this up. Mm-hmm. And generally, if you are the beneficiary, you're able to alter and do certain things within the trust. So trusts are one of those things where it's hard because it can be so personalized. Like you really can do a lot with a trust, but you absolutely can't do that in a will. I've never seen it done in a will.
Because what you're saying is basically she says he can't sell it in the trust, but then he can't afford to pay the taxes, and he can't afford to, whatever the other maintenance or the repairs that the house needs. So he would have to sell it,
Correct.
Okay.
In order to maintain the asset. Correct.
Unless she has so much money that the trust.
That she can maintain it herself. Correct.
Okay. I gotcha. Maybe you can convince her against that. All right. Try to get to her soon though. Kimberly, where do I check or monitor deed ownership online to prevent scams in Georgia?
You can register. So one, you can go down to the courthouse, physically go down to the courthouse, any courthouse, and look it up. You can go online. It's called GSCCCA. You can go into Georgia Superior Court Cooperative Clerks Authority. There's a lot of
I'm
C's.
putting it in the chat just in case. And they
Yeah,
probably have a similar thing in most states. So where you
they
can basically
do.
look up a deed online.
Yeah.
So you can look up yours online.
Yeah, but this is specific to Georgia. Those are the sources I use for Georgia. And Georgia also has an online system, like an alert system. If you go to the county clerk, I don't remember what the name of the system is, but if you go to the county clerk page, I want to say Clark and Fulton have it up on their website. You're able to get an alert if something's happening with your property.
Oh, wow. All right. So everybody else is outside of Georgia. See, because this is like a nationwide thing, this deed theft, you want to just see what protections you have, right? All right. Yanira, that's pretty. Do we need a deed of death transfer if we have a will?
So yes, there's going to be, it's not really called a death transfer. It's just a particular kind of will. So when you have a will, you have to go through the probate process, and the probate court, once the person is assigned over the estate, you're going to assign a deed from the estate to wherever the property is going. So yes, there is a deed, but it's not really a death transfer. We call it an executor or an administrator's deed.
All right. Good question. Thank you, Yanira. All right. We got Kevin Jefferson on here. I'm putting him. Hey, Kevin. Y'all see? Can you see the chat, Jacinda?
I can.
Okay. Yeah. Kevin's in there. Hey, Kevin.
Hey, that's my BFF.
In the chat. All right. All right. Next question, you guys. And we're at about 36 minutes, halfway through. Jacinda's giving some very, very good information for free. Y'all know you got to pay for a consult. You know, these attorneys bill by the hour. So, thank her by hitting the chat. Her contact information is in there. If you're out of state, you need a referral, reach out to her. If you're in Georgia and you need some help with this, your real estate closing, she does that as well, then definitely reach out to her. Have her assistant's email, her phone number, and address. All right, Cynthia, how do you clear title on heir property if the original owner is deceased and there is no will?
Probate court. And then we're going straight to interstate succession. So the state statute is going to determine who the heirs are. And that's going to determine where the property goes. So we're going straight to probate court. We have to figure out who's over the estate first. And then the property from the estate is moving over to whoever the heirs are going to be at this point in time. So if you're in an escrow state, when it gets time to close it, the escrow company is going to pull title and they're going to clear any liens that are on the property. Right. And if you're in an attorney state, then an attorney is going to pull the title and they're going to clear any liens that are on the property before it gets sold to the next person or before it gets refinanced.
And can you say the Interstate? Am I saying that right?
Yeah, Interstate.
Interstate. So Cynthia will know. She might have not seen at the very beginning. You said if you have children, it's your children first.
Yes, it's your children first. It's the state determination of who your heirs are if you don't have a will. Right? Okay. So yeah, you're right. Children first. And then grandchildren. So it goes out in your personal line first.
Okay. Your children, your grandchildren, your great-grandchildren.
Right. It goes all the way down. But if you don't have any of that, then it goes back up to your parents. And then it comes down. Siblings, parents, siblings. And then it'll trickle back down to your parents, siblings. If you don't have any siblings, like it can go all the way down to cousins. So when we see those like films where like the cousin received like this wealthy, like, $2.5 million and they never met him before, it can be possible if there are any heirs.
Okay. Makes sense. So basically what she's saying, if you don't have a will, you don't have a trust, if you haven't decided before your death where your stuff goes, the state decides where your stuff goes. And that's the general order that they use.
Yes.
And if you have any, and I learned this from another live on probate, if you have half siblings, they're a whole sibling. So you can't be like, oh, that's or adopted. They're, some people feel like, oh, we don't have the same mother. If y'all have the same father and he passes away, y'all are equal as far as, going down that line. All right. Good question, Cynthia. All right. Next question. Hey, Rose. Hi. Great topic. How common are titles in estate names? My attorney said to put the title in my name, but real estate in the will to establish an estate. Then designate adopted children as heirs. So it might be a little bit complicated, but I guess she's saying how common is it to put a title in an estate name?
So it's not really, when we say estate, we're talking about when someone passes. So I think we're talking about two different types of estates, right? So when we're using estate in this context, we're saying when you die, what's called the estate is all your assets are called your estate. So that's what we're saying when we say estate. So that's what we're referring to. I think what your attorney referring to is something a little bit different. But your adopted children are your children, according to the law. There's no extra things you have to do for them outside of your original children. But I really recommend that you guys plan. Like, you don't have to plan. I mean, they're going to be treated like your children, but I really recommend that you plan. I recommend that you figure out who's going to have what, put it in your will, use the special deeds, use trust, whatever it is that you feel like is the best avenue. Plan ahead of time. If you plan ahead of time and everybody knows your wishes and you go ahead and make it so, it's going to make the process of when you do pass so much easier.
All right, good to know. All right, our next question, Clark. Hey, Clark, do you think people should do a transfer on death deed at closing when they buy a home, or not? Like, should they do that at closing?
Yeah, we can do it at closing. When it comes to spouses, I think it's so much easier. I just think I don't recommend it for like a parent-children relationship off the top. I feel like sometimes the children can prevent the parents from doing things they want to do with their properties while they're still here. But when it comes to spousal relationships, I always offer it and I always recommend it.
Okay, good to know. All right, and I have that. While we're waiting for the next question, I do have that. So we have a trust as well, but we're joint. My husband and I are joint tenants with rights of survivorship. Something happens to me, the house is 100% his. If something happens to him, the house is 100% mine. So that's what it means, like transferring at death. You can own it differently though in some states. As tenants in common. So if I had other children, my 50% could go to my children. So it depends on how you set it up.
Yeah, in Georgia, you can still own it as tenants in common as well. That's the default. So if you don't specifically say joint tenancy with right of survivorship and there's more than one person on the deed, the default is tenants in common. We just offer it because people don't know about it. And I think when it comes to a spousal relationship, it's the best type of deed to have.
So ladies, I would say this, if you are not on the mortgage, and because I think when you're on the mortgage, pretty much you're, automatically on the deed. But a lot of times when you're not on the mortgage, then it's kind of optional. Like that somebody has to add you to the deed. You want to pay attention to make sure, especially if it's a second marriage, all of that kind of stuff. You don't want to be in this situation where if something happens to your spouse, right? The house doesn't go to you, the house might go to their kids. Just make sure that how you own that property, especially if they don't have a will or they don't have a trust or, they don't have those things, you need to make sure you're protected. So, because I have a lot of couples where maybe the husband a lot of times might just be on the mortgage and on the deed, and they have to add their wives. You want to make sure that you're added as a, with something happens to your husband, the house is yours for the most part, unless y'all discuss something different.
Yeah, you definitely want to, because you can't do anything with the property either. If something happens, you have to go through the probate process. So even in a perfect world where there's a perfect blended family and everybody loves everybody, you still have to go through the probate process before you can do anything. Like you can't call the mortgage company. You can't ask, you can't do anything with the property. You don't have any rights to it. So what you want to make sure that you're somewhere on that deed. If you're not on the mortgage, it's almost a must that you be on the deed, unless you guys have a different arrangement.
All right, good. A must. Y'all hear that? A must. But make sure, because a lot of times they're there at the closing, but they're not paying attention. And I can't, a lot of times that real estate agent, I can't say, oh, make sure you got, So yeah, I just make sure. Deborah said, yes, please bring Jacinda back. Jacinda, everything. Thank you, Deborah. I appreciate it. All right. While we're waiting for the next question, we have 125 people on getting good information. Please hit the like. If you're not already subscribed, hit that. Jacinda's information is in the description of this video for those of you watching the replay and also in the chat. All right, what process should I take to get my parents' home in my name or my siblings' name? I want to keep the home in the family. They still own a mortgage. They still have a mortgage. So how can,
Okay, so if keeping it in the family is the primary objective, you want to look into a trust. Okay, so you want to make sure that this remains a familiar property. You want to keep it in the trust. A trust is the best vehicle for that. If you just want to make sure it goes to you or your siblings, you guys could look at the special deeds we talked about, like the deeds with survivorship, or you could just make sure that it's designated in a will who it's going to. Because, I mean, if there's 4 of y'all, technically the home could go to all 4 of y'all. I don't always recommend that because it's difficult to make decisions and do stuff with property. But if you guys get along, like me and my siblings get along, we kumbaya over here. So if my parents want to leave all 3 of us on a property, it would be perfectly fine. Because we all have similar thought processes. So, there's multiple ways. It just depends on your family dynamics. So if y'all all get along, it's a lot easier. If y'all don't, a trust. If you feel like spouses,
that one family member that don't want to sell mama's house.
Well, yeah. And if you feel like their spouses are going to get in the way, a trust is a surefire way as well. Because you got to remember, like if it goes to you guys as individuals, like say there's 4 of y'all and it goes to 4 siblings. Well, something happens to one of the siblings, their share goes to their heirs, which could be their spouse, it could be their children, it could be a number of people. So you just want to keep that in mind. If the family dynamic is the most important part, a trust or a company, right? Because a LLC is a cheaper way to do it. You could do it in an LLC or a corporation as well, and it have the same effect.
Okay, very good question. Very good question. What are the tax implications? Good question. I think Melia, I know I'm saying that wrong. I'll get it back in a minute. What are the tax implications for your children if added to your deed? So if you add your children to your deed, do you have any tax issues or do they have any tax issues that you need to watch out for?
They could. I mean, there's always tax implications because it's treated as an asset. So you got to be mindful of that. Now, when it comes to houses, tax implications are on the point. It's on the base. It's on basis. It's what they call basis. So it's an individual tax determination based upon your own personal scenario. But yeah, you have to be careful. Before you do that, I would contact a CPA. I'm just being honest. Just don't put your children in a situation where it's going to hurt them more than it benefits them. So before you add them, based upon your situation, I would talk to a CPA and see how that would affect them. And we're talking about, you need to be asking about, hey, how's that going to affect them when they fill out their FAFSA? Like what stage of life are they in? Are they in high school? Are they in college? How's that going to affect their college? How's that going to affect their qualification for scholarships or other things? So that's something you want to talk through with the CPA.
And then a lot of people ask me, because this, I have a lot of first-time home buyer videos, of course, and then they, a parent adds them to a house. Do they already own a property? So when they're trying to do like first-time home buyer grants and that sort of thing, sometimes in some states, they may not qualify because they already own a house. So just be careful with that as well. All right, good question. Kimberly, what are the pros and cons of putting your house in a trust?
So it depends on the type of trust, right? So there are what we call revocable trusts, which there aren't a lot of cons because you can move in and out of a revocable trust. But there are irrevocable trusts, which you can't move quickly. So irrevocable trusts typically can't be taken back, right? Once they're created. Now there are some extreme legal ways to get out of an irrevocable trust, but it's difficult. It's meant to be a permanent vehicle. So you got to be careful. Typically, there aren't a lot of lenders that will refinance in the trust. So you have to think of that as well. So, if it's not a clear and free asset, or if you want to take advantage of the equity, sometimes you can't do that if it's in a trust. Sometimes they won't lend to a trust. Sometimes it has to be an individual. Sometimes companies, they won't lend to a company either. So with an irrevocable trust, it's a little more stringent. It's difficult. It's more difficult to change or get out of. A revocable trust, sometimes they're not even recognized because they're too flimsy. I can get out of it too easily. They don't have the same benefits as a regular trust. You don't get home. So I would say one of the cons is you won't get a homestead exemption. So a homestead exemption on your taxes is like, I basically get a break because this is my primary residence, right? So different states call it different things, but whatever the tax break is that you get because this is your primary residence, you don't qualify for that with a trust or a company, and you don't qualify for any like senior citizen, veteran, active duty slashing of property taxes either. I'm trying to think what else.
I'm trying to think. I have a trust, and I think automatically the attorney that did my trust put the house in the trust, and I'm trying to think of why she did that. But I think it's like, say my husband and I died together. I guess the house is in the trust, and what we said, how that house is going to be split amongst our children, those rules are in that trust.
And so your children are minors. right?
Yeah, they're minors.
Yeah, so that
I
makes
think
sense.
they had to be in there together. Like the house had to be in the trust, and the rules that we have for the house had to be in the trust.
Correct.
So I think that's why my house is in a trust. But again, if you have older children, it might be different. But when I got my trust done, my kids are still under 18. They're 11 and 13. And at the time we did it, they were probably like 6 or so.
Yeah, makes a lot of sense.
So they put the house and everything in there, like, because we have rules, like you can't get anything until you graduate from high school. You can't get anything if you ever been to jail.
Yes,
we have like little
absolutely.
rules. So
guide them if you're not here. Guide them if you're not here.
Yeah.
I always ask people, because a lot of the gurus like to use trust for everything, and I just don't think they're appropriate for everything. So my question is why? Yeah. Why do you think you need a trust? Why do you want to trust? Because trusts are expensive. They're not a cheap vehicle.
Yeah.
Okay? And you still have to file, you still have to maintain it.
Right.
And you still have to, file.
Find one of these attorneys that's offering a sale. Mine was on a sale. And I think her normal price, I think, was about like $5,000. She was having like an end of the year sale, like $2,500. I was like, we got to jump on this, and I got it done for like 50% off. It's like a Black Friday.
$2,500 is a good price.
It was a good price, and it got all done, y'all. So if you ever, get on these attorneys' websites, or they might have a sale every once in a while. Yeah. All right, but it is more expensive. All right. Thank you for that question. Ty again. Okay, let's see. Even if the owner has a will, it still goes through probate, which isn't free, correct? Is there any way to avoid probate entirely? I'm gonna answer this question because I know. Yes, if you have a will, it definitely has to be probated in every state, I believe. Yep. And usually probate, let me say this. Probate could be free if you do everything yourself, but I think the probate court charges you. If you don't get an attorney, it's not as expensive, but you'll probably maybe want an attorney to help you. So the way that you avoid a probate is a trust, because you don't have to go to court. Everything's already done. That's why trusts are a lot more expensive. But give your legal advice. That's why I put in my 2 cents.
No, a trust is one way. You could put it in a corporation. You could put it in an LLC. That's a way to avoid. You can use the special deeds, the joint tenancy deeds we talked about, or you could just go ahead and deed it to them. Period. Just turn the asset over if you no longer have use of it. So you have multiple options of ways to avoid probate.
Okay. Good answer. I saw a question. Oh, a super sticker. Thank you, Rose, for the sticker. I really, really appreciate it. Thank you. All right. Yanira. All right. I'm a beneficiary on my mom's will. I'm married and I have kids. If God forbid I pass, would my husband have any rights to the property?
Possibly.
Okay.
So you need to dictate how you want your assets to go, and you can dictate potential assets as well.
Okay. So basically, you need a will. So your mom has a will. If your mom passes before you, and she leaves you everything, I guess, in the will, right? Then you have everything. Then you have to decide where you want your things to go, because now they're your assets.
Right. And now they're your assets. If you could, as soon as you get the asset, you could put it in a company. You could put it in a trust. You could, put your kids' names on it, depending on how old they are. Right. Like, there's things you could do to protect those assets from being a part of your estate when you pass. But let's say you didn't do anything, then it would be just purely on your will.
Okay. Good. I just wanted to throw out really quickly how to contact Jacinda. She's part of the J. Walker Law Group in Atlanta. Her phone number, 470-761-0152. Direct line, 470-528-2930. And then closing. So all of that is in the description of the video. And it's also in the description of this video. Plus, it's in the chat. I want to ask a question real quick. And I think we have a super chat. We'll take that next. And this is just a little bit off from the will thing. I'm not going to hold you too long. But I get so many people, and you've said it a couple of different times. I wanted to make sure. I'm going to buy my house in my company's name. I'm going to buy my house in my, that's been a lot popular, right? Mm-hmm. They want to buy all their assets in their business name. Speak on it a little bit, because I know you do a lot of investment property. This is typically what I say. At some point, either your business has to qualify for that asset. Like, your business has to have enough income to qualify on its own. And if it doesn't, they're going to attach it to your personal, assets at some point. Just speak a little bit more to that, to like people buying a house in their business name, people buying a car in their business name. How does the business itself need to qualify, I guess, for that?
It depends on the lender, right? If you're going a traditional lender route, typically yes. If you're going private or hard money, typically no. But what happens is that they may allow you to deed it to your business name, but you are personally responsible for that mortgage. It's how they do it. So your business, and so you're really not buying it in your business name because you have a personal guarantee against the mortgage. And they're considering your personal credit on the mortgage. But you generally, when you do like private or hard money, it's asset based. So they're not as concerned with you as an individual or your business, right? So private or hard money, but you're usually not going to buy it. They're going to contribute a percentage of it, right?
Okay.
You're getting a percentage of the ARV. You're generally with private and hard money, you're not getting 100%.
Yeah, because I think when people say that, a lot of people think, well, I just open up an LLC and I buy $1 million property.
No, absolutely not.
That's not how it works.
So if you straight out, there are people who straight out buy in their company name, but it's because they've established it. So they have flipped houses and now they've refinanced it into their business name. Their business has assets. They have business credit. They have business credit cards.
Business has to qualify for it.
Yes, the business qualifies for the actual mortgage that they're taking out. Otherwise, most investors, when they say, oh, I did this in my business name, they did technically, the property is deeded to their business name, but I haven't seen very many private or hard money situations where there's no personal guarantee. I haven't seen very many.
Very good. All right. So let's see. We have 2 super stickers. Cynthia, thank you. Cynthia Slaughter gave us a super sticker. I really do appreciate that. I don't know. I'm going to we're at, you guys, 7:56. We're going to try to do 5 questions. I'm not sure if we even have 5 questions. Let's do our last 5 in this 5 minutes. Moderator, could you pick up the next one? All right. T. Oh, T look a little cute. T. Sunglasses. All right. My grandmother is leaving her house to me. She may be passing soon. I'm sorry to hear that, T. Her kids agreed I can get it. Let me read that again. My grandmother is leaving her house to me. She may be passing soon. Her kids agreed that I can get it. I guess those are your aunts, uncles, maybe. She owes $50,000 on her mortgage. How should he get the house? Not sure if she owes money to the nursing homes.
I'm going to tell you real talk. The best way is for her, if she's coherent and she's in her right mind, is to go ahead and get her to deed that property to you. Now, there's no point, especially if she's in a nursing home, she doesn't need the asset. So the best thing would be to go ahead and just deed it to you now. If not, she can designate it in a will that it goes to you. That could be one way. And you can use a special deed, the joint tenancy deed, depending on what state you're in. That could be a way as well. But when you're old, when she's up in age, as long as the nursing home doesn't require that asset to be in her name, like as long as there's like no Medicaid liens or anything crazy going on with the property, she can just go ahead and gift it to you now.
Sorry, Jacinda, should he get a lawyer to do that paperwork for him in his state?
Absolutely, please.
Or her state, right?
Yeah, in her state, wherever the property is.
Wherever the property is,
okay. She might be in a nursing home in a different state, but wherever the property is, you need to get an attorney in that state to oversee it and to make sure it's done correctly.
Okay. If he's in Georgia, can you do it?
Absolutely.
Okay. Her information is in the contact. All right. So we're definitely sorry to hear that. Praying for your grandma. But yeah, like she said, do it, have her deed it to you if she can, if she's able to. All right, Deborah. My uncle owned a house in New Jersey. He did a reverse mortgage. He, wife, and daughter are deceased. So he's passed away, his wife's passed away, and his daughter are deceased. Somehow they got my name and they're coming after me. My name isn't on the deed or bank papers. Is this legal? So I guess the reverse mortgage company is coming after her?
Yeah, they don't have a basis to come after you unless they think that you're the heir. So if they think that you're the remaining heir and you're going to be the heir in the estate, that might be why they're trying to contact you. But as far as like responsibility for it, typically you would have a responsibility for it if you're not a direct like heir. Typically what the reverse mortgage company is going to do is just foreclose on the asset. So if he doesn't have any heirs, they might be reaching out to you in order to foreclose. Or they might be reaching out to you and anticipating that you're going to be a part of the estate of your uncle, since the wife and the daughter are also deceased. So it depends, but financially responsible? No, I've never heard of someone being financially responsible for a reverse mortgage as a distant heir. No.
Right. Should she look into it? So say the house is worth 500,000 and the reverse mortgage people are going to get 200,000 of that. Should she look into it to see if she is there?
Okay. Yeah, absolutely. If they're contacting you, I would see why. I would see who's over your uncle's estate. If the estate has already started, see who's over it. If it hasn't started, go ahead and start the process. Like, look into it. Look to see how much the house is worth. Is it worth the process of going through? Oh, you're not an heir next of kin.
I'm not the heir or her next of kin.
That doesn't make sense. Yeah, that doesn't make sense. I honestly would consult with someone in New Jersey just so you can get an understanding of what's happening, just to make sure nothing's being missed. Because that doesn't make sense to me.
Maybe she had a will you don't know about and she left it to you. You never know.
Or maybe you don't think you are the next heir, but they think you are. So.
All right. So that was question, I believe, 2 of 5. So we have 3, 4, 5 left. I'm not even going to try, but Agnes, last name, the Agnes. How come the house price goes down, but the property tax remains the same? How do they calculate that tax? And I guess we're going to have to talk very general right now.
Yes.
How do the price taxes go down? How come the house price goes down, but the property tax remains the same?
So certain states generally charge a percentage of property tax, a percentage of the value of a home. Right. So they're not saying, oh, your home. So generally, like, it'll be like somewhere between, I don't know. Let's just give an example. Let's just say that the state only charges 30% of the value of the home. And then they base it off of that 30%. So what could be happening is why the property tax remains the same is that the actual rate of the property tax is going up, even though the value of the home is going down. So if your property tax rate is going up, your taxes are going to increase or stay the same, even with the value of the home going down. So it just depends. It's so state specific. I can't give you an example to say for sure how your state calculates or your county, because that's another thing too. Like if you're in a city, you got city taxes that could be calculated differently than the county taxes. Right. So,
and I would pause and say real quick, I would pull the prior years, like pull like 2024, 2023. I mean, yeah. Pull the last few years of taxes and see if that percentage, the millage rate, see if that percentage changed, see if the value changed. If that, like you said, if that percentage is going up, but the value staying the same, you're probably going to, or going down, they're probably going to wind up paying the same thing, right? So look at the last few years and kind of compare it to see what's changing.
Yeah, and you can always challenge too. Typically states have a process where you can challenge the property tax. You have to do it in a certain window. You typically can challenge what the state has as the value of your home to challenge how much you're paying in property taxes.
All right, I'm going to pick question number 4 because I think it hasn't been asked yet. Marie, James, what do you think about title insurance? Those of you, if you don't have a house, you already have a house, a lot of times at closing, you'll be asked, if you're having a mortgage, the lender's going to get it regardless, title insurance, but you'll be asked, do you want a homeowner, like a owner's policy for title insurance? What do you recommend? Like, do you think everybody should have title insurance?
Oh, yeah.
And then some people try to skip over it with new construction. So let's talk about resale title insurance and new construction title insurance.
There is no difference. There is no difference in resale and new construction title insurance. And with new construction, it's almost even more important that you have it because that's typically where we see mistakes. So new construction, when you have a neighborhood and you have a development, and what they start out is a big chunk of land, and then they have to parcel the land up, right? So with the parceling and the surveying with new construction, it's typically where you see errors on the lines because they just built the house, right? They may have reviewed, the survey might be wrong. The builder may review the survey wrong. That's where you see a lot of errors. So with new construction, it's even more important than it is with resales. But the title insurance itself is the same. What title insurance does is it protects you in the event that something happens, right? So like I said, depending on the lender, we'll go back 50 years. Sometimes we'll go back 100 years. It really just depends on the parameters of the lender. But something 200 years could have happened. Something could have happened that we missed as a closing firm that didn't show up when we pulled title. or that was outside of the scope, right, that we were required to search. And what title insurance does is say, hey, this error happened, but you're covered, and we're going to make you whole, right? We're going to go to court. We're going to quiet title. We're going to pay it off. We're going to do whatever it takes to make you whole. That's what title insurance does. I always tell my people at closing, if the lender requires it and they aren't willing to do a closing without it, neither should you.
Okay.
You just shouldn't.
That makes a lot of sense. Do you have a horror story to tell us? Somebody who didn't get it, or?
Yeah, I do actually. So
Okay.
this $2 million house. So why would you do this with $2 million? $2 million house is like
a couple of dollars.
Listen, it's like 8 of them in a row, right? This builder built them custom houses. Every single one of the houses encroached on the other lot, right? The surveys were off. They were incorrect. So there's encroachment issues, and the last person doesn't have title insurance. So they're having to pay out of pocket to figure out this new arrangement. And basically what's happening is they're trying to negotiate a new boundary arrangement, because like the driveways, the fences, the corner of the houses are on the next lot. And you know how most judges aren't going to make you pick up and move 8 houses to the left. It's just not going to happen, right? They're going to try to come up with an agreement. But the problem is the agreement is in Superior Court. So they're shelling out, by the time they got done with the dispute, they shelled out somewhere around $50,000 in attorney fees that would have been covered by title insurance. So when we talk about real estate is typically in your superior courts. Like if you're in Georgia, are they typically in a court that deals with real estate and that requires attorneys? So we're talking, we're not talking $3,000 to $5,000 when we talk about superior court. We're talking about we're starting retainer of $10,000 to get started with superior court cases. So you just have to keep that in mind.
All right, very good question. All right, we're gonna let me see. I just want to recognize Deborah really quick because she had a super chat. If the moderator, can you put that up? I found it. All right, Deborah, thank you so much. She's saying thank you to you probably.
Oh, thank you.
Thank you so much for giving back. Thank you, Deborah. And I hope everything does work out. You might be coming in like, to an inheritance that you didn't know about. So you never know. I would just follow up on it just in case. And put up that last question, moderator, please. Because I'll put it down. And I want to say this is our last question for the night. Please. It looks like a good one. Hold on. I don't know if it's a good one. Let me see.
Maybe not.
But maybe not. Let's skip that one.
Yeah, okay. We'll skip it.
They're not really asking a question. We can put that one down, moderator. I'll try to pick another one. But go ahead and like and subscribe if you haven't already. I do have all of Jacinda's information. I want to put that back up on the screen. I'm trying to make sure we got everything else. Okay. I think we're good, Jacinda.
Yeah,
I want to say thank you.
I'm so excited.
Yeah, give them how to reach you again, please. And I'll put it on the screen while you're doing that.
So I'm at the J. Walker Law Group. The law firm's number is 470-761-0154. You can reach me at admin at the J. Walker Law Group or Jacinda at the J. Walker Law Group. Either one of those emails work. We cover the entire state of Georgia. When it comes to closings, we're mobile. Again, so we cover all real estate issues. We're a full service real estate firm, and we also do business law and contract law. So we specialize in helping small businesses navigate the things that they need. So whether it be letters, review of contracts, forming contracts for their businesses, we assist with that as well.
Okay, excellent. And we will have her back out to tell y'all how to get these houses for $1,000 and $500 and $2,000 with tax lien. So hopefully we'll have her back. I'm gonna check her schedule, and hopefully we'll have her back out in January to talk to you guys about that. Thank you so much, Jacinda. I really, really appreciate you.
Absolutely.
And having you out tonight. Y'all have a good night. Hit the like button before you leave. Thank you.
Thank you.